Hi everyone, welcome again. This is Eric Grotebois, EPGD Attorneys at Law PA in sunny Coral Gables, Florida. I am doing something that a video that actually came to me yesterday while I was in a meeting with clients in this office. And so the subject matter is making sure that your corporate documents mean what you say, what they say what you want them to say. That's or want them to mean. And in any case, what my point is that I was having a meeting with these clients. And in this case, there were 5 different shareholders. Okay, this is a corporation, a Florida corporation, so we call them shareholders. And really, there were 2 guys that were working in the day-to-day, and the other 3 were kind of silent partners. One had put up some money, one of the silent partners. The other 2 had given some sweat equity. And so at the end of the day, what we really had was a closed company that was very interested in maintaining continuity for the 2 gentlemen that the 2 main guys, in fact, the 2 people sitting right there across from me. And so the 2 guys, actually, I'm going to draw it on the board because I think that diagrams are really useful. And so this diagrams, you guys have probably seen me do them before, but actually I got them from my corporate tax professor in law school. So the way it always works is the owners are on the top and the stakeholders are on the bottom. So here we got the company in the middle. It is a Florida Corp. Okay, and the Florida Corp has shareholders. In this case, we had 5 shareholders, and we'll just call them A, B, C, D, and E. Now, D and E, 10% each, or 10 shares each. All that they had given is sweat equity, which basically means they're given some of their expertise. They're given some of their knowledge. And in this particular business, these guys each had special knowledge. This person, who was going to have 30%, gave a whole bunch of money. Now, these 3 are, for all intents and purposes, silent, meaning that they're not going to be involved in the day-to-day running of this company. Now, these 2 guys are going to have the remaining 25 and 25, okay? And they're actually working for the company, so they're also putting in sweat, okay? And so the meeting I had was with these guys. And what they wanted me to look at was their shareholders agreement, and they wanted me to look at their bylaws. Now there's one more document that they didn't have me look at, but I went ahead and pulled it off of the Florida State website, sunbiz.org, and that is the Articles of Incorporation. By the way, for an LLC, they're called Articles of Organization. So anyways, the Articles of Incorporation are like the birth certificate. They get approved by the state, and they usually give the bare minimum information. Now, most of the time nowadays, people are doing this online, but in this case, they also did it online. But you can do it the old-fashioned way. You can actually write out complicated articles. If you just use the online form, they all look the same. So anyways, what they wanted me to do was to look at this, and to say, hey, if something happens to one of us being A or B, we want to make sure that our family gets paid and that the other person continues to run the business. So if something happens to B, B's family gets paid, and then A keeps going on. And so the idea that we had was, why don't we have 2 different classes of shares? We'll have our voting shares. A and B will have voting shares. And the voting shares will be, let's say, in this, okay, so let's do it this way, right? We're going to have voting and non-voting. Right? And so at the end of the day, there's 2 things that you can think about. You can think about your percentage of power, and you can think about your percentage of dividends. Right? Dividends is getting money. So basically, these guys are going to have no vote, but they're going to get paid whenever the company has money to pay out. And these guys are going to have all the vote. So if something happens to one of them, what they were going to do is fund it with a buy-sell agreement, which is actually a clause that's included in the shareholders agreement, although sometimes I've seen it as a standalone contract, buy-sell. And so the buy-sell agreement says that on an agreed valuation, which they're going to redo every 2 years, that the company is going to buy life insurance on each of these guys' lives, so that if B dies, the company is going to get a check from the life insurance company, and then it's going to be obligated to pay that money directly or immediately to B's family or A's family, respectively. And then afterwards, this 25 would disappear, right? And then we just keep going, and everybody would pro rata have an increase in their ownership. But most importantly, this guy would keep his voting power. So what's important is none of their documents said that. and whoever drafted it for them never asked them the tough questions of what they actually wanted. So work with your corporate lawyer, make sure you figure out you're getting what you want, and this is Eric Rodebois from EPGD Land.